Learners. Hello friends, welcome again on Pharma Learners. In this tutorial, you will learn about types of patents, exclusivity, and about Hatch-Waxman Act. Before start, let me tell you that what we will discuss in this tutorial you will learn about types of patent, certifications, and exclusivity, from where these paragraph certifications comes. You will know about the Hatch-Waxman Act and why this Hatch-Waxman Act was required, how this Hatch-Waxman Act helps innovators, and how this Hatch-Waxman Act helps generic drug companies. At the time of filing an ANDA application, which is also called as generic drug application, an applicant must provide information related to any patents listed for the reference listed drug, also called as RLD, in FDA's approved drug products with therapeutic equivalence evaluations, which is commonly called as the Orange Book. In its ANDA application, a generic applicant must submit to FDA 1 out of 4 certifications specified in the Act regarding the patents for the RLD. These certifications are Paragraph 1 certification, Paragraph 2 certification, Paragraph 3 certification, and Paragraph 4 certification. Now let us understand all these certifications, one by one. A Paragraph 1 certification states that there are no patents listed. In this case, FDA may approve the ANDA application immediately. One or more applicant may enter in such case. In the ANDA application for Paragraph 1 certification, applicant must certify that such patent information has not been submitted by the new drug application, NDA, holder, innovator, for listing in the Orange Book. Paragraph 2 certification. Paragraph 2 certification states that the listed patents have expired. In this case also, FDA may approve the ANDA application immediately. One or more applicant may enter in the market in case also. In the ANDA application for Paragraph 2 certification, applicant's patent certification must state that such patent has expired. Paragraph 3 certification. In Paragraph 3 certification, the listed patents are not expired and will be expired on a specific date. In this case, FDA may approve the ANDA application which is effective on the date of expiration of the patent. One or more applicant may enter into the market in this case also. In the ANDA application for Paragraph 3 certification, applicant's patent certification must state the date on which such patent will expire. Paragraph 4 certification. In Paragraph 4 certification, generic product applicant does not infringe on the listed patents or that those patents are not enforceable. In this case, generic applicant provides notice to innovator or patent holder. Entry of first to file may or may not occur in this case. Now, let us understand that, from where these paragraph certifications comes. In 1984, U.S. Congress passed the Drug Price Competition and Patent Term Restoration Act, which is commonly known as the Hatch-Waxman Act. As per the rule of this Hatch-Waxman Act, innovator, or we can say, branded drug companies, are required to list patents which includes composition including substance, formulation, and method of use in FDA's Orange Book. However, generic drug company, or we can say ANDA, applicant, files an abbreviated new drug application and certifies against any 1 out of 4 types of patents certification listed in the Orange Book, which we have already discussed in this tutorial. Now, I will tell you about how this act named as Hatch-Waxman Act. Actually, the official name of this act is the Drug Price Competition and Patent Term Restoration Act. In 1984, this act was sponsored by Orrin Grant Hatch, who is an American attorney and politician, serving as the senior United States Senator for Utah, and represented by Henry Arnold Waxman, who is an American politician who served as the U.S. representative for California that time. Since then this act was informally known as Hatch-Waxman Act. Now we understand why this Hatch-Waxman Act was required. In the early 1980s, U.S. Congress observed that very few generics were coming to market after expiration of the patent. After studied the issue, U.S. Congress found that generic drug companies were facing difficulties that time for marketing generic versions of innovator products after the expiry of the patent due to irregular and uncertain regulatory pathway for filing the ANDA. It was also observed that there are some regulatory delays too in marketing of drug products faced by innovator, or we can say branded drug companies. The Act provides protection to drug innovators. On the other hand, this Act also encourages generic drug companies by facilitating and providing incentives for companies to file a NDA. Now the question is, how this Hatch-Waxman Act helps both innovators as well as generic drug companies? So, let us first start how this Act helps innovators. As per this Act, drug innovators were provided protections in following ways. First, this Act has introduces with a new kind of market exclusivity. Under this clause, new 5-year period of data exclusivity awarded when the FDA approves marketing of a drug that is a new chemical entity. During that period, the FDA cannot approve a generic version of the drug. Second, this Act has made provision for the extension of the term of the existing patent for innovator drugs, if innovator discovers new indication or new dosage form of the patented drug. Third, the Act also has the provision to allow the life of patents covering a drug to be extended by duration of the time the drug is under regulatory review by the FDA, which ensuring innovator companies that regulatory review will not unduly put away patent life. Under this Act, the drug innovator requires to provide the FDA details about the numbers of patents innovator believes cover its drug. FDA publicly lists those patents in the Orange Book without evaluating whether the patents cover the drug or not, and also states that in case of regulatory delay in approval, the life these listed patents gets extended. Now let me explain you that how this Act helps generic drug companies. First, this Act has made provisions for the marketing of generic versions of patented drugs on the day after patent expiry. In this case, a generic applicant only requires to scientifically demonstrate that its product is bioequivalent, that is, performs in the same manner as the innovator's drug, and need not to provide the preclinical means animal and clinical means human data to establish safety and effectiveness. This application is called an ANDA or generic drug application. Second, this Act provides opportunities to challenge the validity of patents issued to innovator drug companies by generic companies. This is called an ANDA with a paragraph 4 certification, and if ANDA gets approved, generic applicant gets 180 days exclusivity. Now it's time to check your knowledge. I am requesting you to read the questions carefully and give your answers in comment box below.